Good morning, and thank you for joining us for today's Workers' Compensation 202 webinar. I'm Sarah McDonald from the Board Stakeholder Engagement Unit, and joining me today is Joe Cavalcante, the Board's advocate for injured workers. Today, Joe will take a deeper dive into best practices workers can use to access their compensation benefits, including understanding labor market attachment, details on benefit periods and how benefit rates are calculated, the importance of items such as the degree of disability and the Carrier Continued Payments (CCP) order, how advocates can help workers and comply with privacy provisions, and the Workers' Compensation Board's new medical treatment guidelines. We'll be taking your questions via chat today. You may enter your questions throughout the presentation in the chat box located on the right side of your screen. Joel will answer as many of your questions as he can, but if there are any that he doesn't get to, or if you think of something after the session ends, we'll be providing you with additional resources at the end of the presentation. Your name and email were given to us when you registered. However, if you have a specific topic you'd like to discuss more in depth with the board, please share that topic along with contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are set so that only panelists can see questions or comments that come in, so you don't have to worry about others seeing your contact information. And with that, I will hand it over to Joe, and we will go ahead and get started.
Good morning, Sarah.
Good morning.
And hello, everyone. Thank you so much for joining us on April 29. I mentioned that because yesterday, April 28, was Workers' Memorial Day, the day when we specifically mourn the dead and fight like hell for the living. This is when we remember all the workers who perished on the job or because of their jobs. And that probably includes everyone on this call, as in everyone on this call very possibly might be covered for workers' comp. We are going to consider a number of important topics here. Generally speaking, we shall begin with some important background, and then we will do a whole lengthy section on indemnity. The lost wage payments, the rules, the idea of labor market attachment, which I notice from the pre-registration or the registration process, a number of people are interested in. You've got it, we're going to cover it. Then we're going to cover medical care, and then we're going to do this section that I really enjoy because it's best practices for payers. I'm going to explain to you how the board is interpreting things and, well, what the board expects from payers in certain areas. And then we will end with the ever popular topics of appeals and settlements. We will answer the famous question, what's a settlement? Let's begin with who I am. Who's your speaker today? The advocate for injured workers is actually an ombudsman. If anyone wants to pull Workers' Comp Law Section 13-H, you'll see that the legislature put forward an idea and the governor signed it about 30 years ago now, I think. As establishing my position, the ombudsman. That means I am here to help injured workers, advocate for injured workers with difficult and complex claims. And one of the ways I do that is I accept complaints, I investigate them, and I attempt to resolve them. I have an office of people who work with the employees who've become injured or ill, or the surviving families thereof, to help access benefits. We are also involved in fatality claims. We work with the families. Yesterday, I was at an event at the Department of Labor, actually, where they dedicated a new space and a new monument, so to speak, particularly for government employees who died during service. And I met the family of someone I'd been working with for 2 years. That was a nice moment. Along those same difficult lines, we also work with the September 11 community. I am the board's liaison to this community, and we are showing you right now some 9/11 assistance programs on the federal level that we don't control, but the governor wants us to make everyone aware that these things are there. They are still there, okay? And they can still be there if everyone speaks. And so on the left, you see the World Trade Center Health Program. Federal government is funding these World Trade Center health clinics, wherein people impacted by the events of that day and the aftermath can get medical monitoring and treatment for conditions related to their World Trade Center exposures. And then on the other side, the Federal Department of Justice is also operating this financial fund that has money available to people who survived or surviving families. And so you would have to apply to them for that funding, that award. So please visit this page and please check into it if this is you or anyone you know, because this situation is ongoing. And then finally, I report directly to the commissioner of the agency, the chair, because that's how an ombudsman works. You see something, you have to go to the person at the top. You can't report it to the people who might, need to make a change. That's just how ombudsmen work. Publications. Oh my goodness. We have so many good and important publications in this agency available to you. Look at this list. Publications for workers. And you can see they're already translated into 10 or 11 different languages. Then we have publications for employers. Then we have medical treatment guidelines, more publications, PFL, public reports, annual reports. So come to our website, please, and then go to the bottom in the teal and click publications. Get yourself all the education you could want. E-case. All right. Workers advocates. What do? You register for E-case. I'm speaking to the workers now. It's very simple. You're going to come here on the website. You're going to click that register for E-case button. And this is all you have to do. Look at the fields. They're easy. The only thing you might not know off the top of your head is your driver's license number, or you might need an alternate thing if you don't have a driver's license. But point is, you're a worker, register for E-case access. You can see every document in your file that everyone else can see who's part of the system, not just members of the public, part of the system, and you will be knowledgeable. Knowledge is still power, my friends. The privacy provisions of the comp board. Okay, you're an advocate. You would like to help an injured worker. You're a spouse. You're a child of an injured worker. There's no automatic inclusion in this system, my friends. What has to happen is the worker has to complete this form, the OC 110A form, it's known. We call it the 110A because in the comp law, the privacy provisions are under section 110A. We're not very inventive in these nicknames, folks, but that's a good thing. Here's your form. It's very simple. Who's the injured worker? That's the top. And then the next section, who does the injured worker designate as eligible to hear details, and then has to be signed? Okay, see on the left it says claimant signature, ink only. You have to sign it and you have to mail it to us. We have to see the original. If we don't get the original, it's not going to be in force, okay? But once it is, you're all set. So please do that, especially if you want to help someone. Let's talk now about the next section, the indemnity benefits. This is the money. Let's say there's a claim filed and the payer decides to formally dispute it. That can certainly happen. And it happens roughly 1 out of 10, 1 out of 9 claims a year at the present rate. So it's going to be disputed or controverted. That is the phrase that we use in this system. Controverted, as in controversy. The insurer has to cite one of a limited number of reasons to controvert, but they can. So what happens is the claim is probably, but not definitely, probably going to go on the expedited calendar, where we're going to wrap up the dispute, hopefully, in 90 days or less. The items that don't go on the expedited calendar would include occupational diseases. Those are extremely complex claims, and the chances of wrapping them up in 90 days or less. So why even attempt it? They're too complex for that. But most claims are definitely going to go on this 90-day calendar. What that means is the law grants the payers certain privileges or rights or whatever you want to term it. But one of them is the payers don't have to pay any money out while this is being disputed. So what does a worker do who can't go to the job every day and earn a living? Well, the worker can file a short-term disability claim. The short-term disability claim is going to give the worker about $170 a week. That's the amount set in the law, my friends. But you file this form that Sarah's showing us here. It's a pretty simple form. You file it with the disability insurance company. You provide the medical report that is necessary, and at least you can have the $170 a week coming in if you have no other income. That is a very viable and accepted practice. You can do this, my friends. Let's say we have a hearing now. Let's say the claim's established, and at the hearing, the judge uses the phrase carrier to continue payment. You see, we have it in that middle block there. In our system, which loves to use acronyms and nicknames, they're just, as I said, they're just not usually terribly inventive. You can figure out what they probably mean. Carrier continue payments is CCP. If you ever hear the phrase CCP, that means that the insurance payer is being shorthanded as the carrier, and a judge has asked that carrier to continue payments at this particular rate. So there'll be a dollar amount. The payer may not stop payments until a judge or a board panel on appeal maybe, but until someone at the board in authority, like a judge, says you may stop payments or payments shall now be at this rate. Okay, so if you're a worker and you get this CCP order, you can probably count on receiving those payments. And I hope you have direct deposit. I will make that plea again in about 10 or 20 minutes. Let's talk now about the degree of disability. I think 2 people might have asked for this particular topic before today's session. This is such an important topic, and I'm going to speak directly to the medical community in a few minutes on this subject. All right, degree of disability means how disabled is this worker? It is also known as the temporary impairment percentage. This is a hugely important piece of data in a workers' comp claim because it's going to be one of the terms in the equation that equals the lost wage benefit. How much money is the worker getting? So, see this table we have here? Okay. On the right is the percentage of disability. It's going to range from 0 to 100. 0% disability, you're healthy. That's great. 100% disability, I'm sorry, but you can't work because you're 100% disabled on a temporary basis. Okay, we're in temporary world here, my friends. Yes, we're in temporary world, although the percentages can carry over in other places. But what I want to tell you here is on the left of the table, as you look at it, you'll see total, marked, moderate, mild. We are showing you those terms because number one, those are old school terms, and some people still use them, and that's fine, but they do equal a percentage. And that's why we gave you this little chart here. Total is 100% in every context. Please remember that because you have total permanent and total temporary. But please remember that. And you can see that it goes from marked at 75, moderate's always half, 50, mild is 25. The providers can use different percentages. They really can. It's whatever their judgment is. It's just that these are the percentages that are by far most frequently used, and they're the only percentages that have I guess that would be an adjective, or a part of speech that's directly equated. Moderate is 50%. Now, let's talk about what benefit rate that yields. If you have a total disability, you're going to get 100% of your benefit. Remember, total always equals 100. Now, you have a 75% disability, you're getting 75% or 3/4 of your benefit rate. So let's say let's do some easy math. Let's say your average weekly wage was $900. So 2/3 of that is $600. So that would be your maximum benefit, $600. You're 100% disabled. How much do you get?
$600.
Thank you. But now let's say you're 75% disabled. You're going to get 75% of 600, which is $450.
Yes.
Thank you. So there you go. That's how the math works. And we do have this really important footnote. The worker is always capped at what the maximum rate was on the date of injury. So even if the date of injury was some distant time in the past, I'm sorry, you're still going to be capped at what was the maximum on that date in the distant past. Now, I'm going to take a drink and Sarah's taking over.
Okay, everyone, we're going to go ahead and launch the poll here. Our scenario here is Susan's indemnity benefits. Susan was 100% temporarily disabled and has been receiving $1,000 a week for the last 3 months. Susan's doctor recently said she's healed to the point where she is now only 50% disabled. Susan has never had a workers' compensation hearing, but what we're looking for here is a true or false question. True or false, because of her new disability percentage, Susan's benefits will now decrease to $500 a week. So it was, because of her new disability percentage, true or false, will Susan's benefits now decrease to $500 a week? And I know that Joe here likes to look at the participation numbers of what's coming in. So we're looking for about 50% of people at least to participate and just clicking either true or false here.
We do, yes, we being me, but I know Sarah likes it too. we would like to see at least 50% of you participate. And I think we should just give them a tiny bit more because we've already passed 50%.
Sure.
Let's see if we can get a record. And please don't be confused by the question. If you think her rate will decline, you would click, well, let's read the question. Because of her new disability percentage, her now will decrease. If you think it will decline, you would click true, right?
Correct. If you think it will decrease, you would click true.
Yes. Okay, so the answer is yes, the payer can cut the payments in half. They can cut it to the 50% level on their own because Susan has never had a hearing. So that means there was never a carrier continued payments order because she didn't have a hearing, and that comes from a judge. So look at that. We tested you on two things there. Okay. Thank you everyone for participating. That is the rule, and that does happen in the comp system every day. Let us now talk directly to our friends in the medical care community. Hello. Number one, thank you for joining our webinar. Number two, thank you for treating injured workers, because if you don't, oh my Lord, what chaos and what pain there would be. We don't have a system without you. Now, please follow along with this simple request if you would, kindly, because it will help the workers and will probably get you paid faster too. When workers are temporary, everyone's temporary unless they have a permanent injury, either permanent partial or permanent total, which we'll discuss in 5 minutes or quicker, but that's down the road. A judge has to say you're permanently, partially, permanently, totally disabled. So everyone's temporary. So if a worker is getting the indemnity benefit, the lost wage payment, if the worker can't work or the work has been changed and the worker's getting a payment, the worker must see the treating provider every 90 days or more. Frequently, that is. Because that provider has to give an opinion on disability. Now, how do you do that, providers? Okay, I hope every provider on this call right now is saying, where do we indicate that? Okay, see that second bullet there? There are 3 magic questions that providers must answer. Is the patient working? Is this condition that I'm presently treating the cause of disability? And then finally, what's the degree of disability? What's the temporary impairment percentage? How disabled is that worker I'm treating? Okay, providers, where do you indicate the answers to these questions? Here is a very simple place where you can indicate them. We here at the board created this medical narrative report template. You can have it for free. You can use it. Please use it. You see the top is just what's your name, who's the patient, and then the bottom part, look at these 3 big blocks. Those are your questions. You indicate your answer right in there. You attach it to your notes in your CMS 1500, you file it, and you go on with your day. If you don't want to use our template, you don't have to. What you can do, I came up with this myself, but I think this is brilliant. Just put these 3 questions in your template of your treatment notes. I know you all have templates for your treatment notes. Put them in the template and answer them. Okay? If you do that, you can keep the lost wage benefits flowing. If they're due, if they're not due, you're going to be explaining why they're not due, and you might even get yourself paid quicker. Thank you for your attention on that. Now, I mentioned that there's temporary and there's permanent. We're going to start speaking now for a moment about permanent injuries. First, permanent partial. This means that the worker is healed as much as possible, and a judge has decided the worker is permanently partially disabled. So that's less than 100% of LWAC, loss of wage earning capacity. I want to pause for a minute because someone just asked a question about acupuncturists. What about acupuncturists answering those big three questions? Well, acupuncturists don't answer those big three questions. There are some types of providers who don't answer those. Acupuncturists are one, physical therapists are another. But if you're a physician, if you're a chiropractor, if you're a nurse practitioner, if you're a physician's assistant, and you're doing the treatment, yes, you're answering those questions. Thank you. Now, back to this. We use a concept known as loss of wage earning capacity, or LWEC, or LWEC. I'm sorry that's awkward, but that's what we do. LWEC. We use that to determine how many weeks of benefits a worker who's permanently partially disabled will receive. We've given you a table here. So you'll see from 96 to 99% of wage earning capacity is lost. That's the ability of someone to earn wages from work. You've lost 96% of that. So you're not total. That would be 100. You'd be eligible for the most weeks of benefits, 525. That's 10 years. And then you can see how it goes down, down, down until if you've lost between 1 and 15%, you're going to have 225 weeks of benefits. That's 4 years. So 4 to 10 years. Now, before we go to the next one, there is something I do want to say about this. Let's say you're an injured worker and you lost 76 to 80%, so 425 weeks. Let's say you're coming towards the end of your 425, but you have decompensated. Your health has deteriorated. As a matter of fact, your doctors are now telling you, I don't see how you could ever work again. They might have said that in the past, but you got the 76%. But let's say they're saying it again. You can apply for a redetermination. That's the key. Redetermination. You're an injured worker. You can amass your medical reports that say, this person is totally disabled. Maybe you have some new condition. Maybe you've suffered some consequential injuries. Maybe, what often happens is PTSD, or I shouldn't say PTSD, usually it's major depression. That does happen to workers who are significantly impaired and they haven't worked in years and they're home. Anyway, my point here is that's just an example, okay? My point here is that if you have doctors who are telling you you're now 100% disabled, you can gather that evidence, come in and ask for a redetermination. You might get reclassified to permanent total. Now, that's actually our next slide right here. If you show that change in condition, then you can ask for the redetermination to either permanent total or total industrial disability. Total industrial disability is another benefit that is so rarely used that I have to call it out here. It yields lifetime indemnity payments the same as permanent total, because that also yields lifetime indemnity payments. It's just that the criteria are a little bit different. you don't need 100% loss of wage earning capacity for total industrial disability, because that will encompass other factors such as the possibility you can be retrained, your level of education, your facility with the English language, for example. Those are all factors that go into total industrial disability. So, between 97 and 99% of workers who are PPD, permanently partially disabled, have attorneys. That's a dependable stat. I pulled it. So, talk to your attorney about applying for a redetermination. That is possible. I have seen it happen, and I know it's done. So if that situation is you've decompensated and deteriorated to the point where you're 100% disabled, you can go down this road for a different benefit. Now, a couple of best practices for those who are receiving indemnity benefits. If you can have a bank account, would you please consider using direct deposit? Sarah's smiling because every time I do this webinar, or any of my webinars, I always make this plea, and I always make it with different levels of emphasis or begging or passion or whatever you call it. But, you know, in the year 2000, the federal government told everyone who gets Social Security, we're doing direct deposit. We're not doing paper checks anymore. That was 25 years ago. If you can have a bank account, I have no idea why you don't have direct deposit. Next, if you get paid in cash at your job, would you please keep some records? Because you very possibly might have to demonstrate what you were earning, right? Like if you have a comp claim, for example. So if you have records, that's pretty persuasive evidence, wouldn't you say? And we're just talking about, just write down who paid you, how much money, on what day, and what you were paid for doing. Now, the last tip. Please, if you file a C3, if you file your own claim form, or even if you don't, but especially then, would you please include the address of the location where the incident happened? This is particularly important in construction jobs in cities like, I don't know, New York City maybe? The reason is, if you're in a construction incident, number one, yes, construction's hazardous work. We get a lot of claims out of construction. Number two, New York City is the place in our state that has the most economic activity. That's where we get the most claims from. And then finally, if you give us the address where the incident happened, we can pull the building permit. Because there will be a building permit, almost certainly. And then we know all the contractors who are on site, so we can very quickly sort out who's the general, who's the sub, whose policy prevails here, okay? And if you represent injured workers, if you're helping with a C3, get the accident site, please, the accident address, because we're only going to save maybe 6 months, maybe a year, maybe 2 years of hearings. Seriously. Thank you, everyone, for listening to that. Now we come to labor market attachment, a very high demand portion of our webinar today. We're going into temporary world now. We're going back to temporary world. And let's say we have a worker who's temporarily disabled at less than 100% disability. Look, we're back to those degrees of disability again. So if you are temporarily partially disabled, there's our terminology, you as the worker can be asked by the judge, okay, it has to come from a judge, to look for employment within your restrictions. You're going to be asked to do this to continue your indemnity payments. This is a requirement to prove your labor market attachment. We have a substantial web page on this, and here it is. It's on the board's website. You can come and read it for yourself, and we have all the info that I'm about to tell you on this website. Okay. So here's what we now need to know. The insurer would raise this obligation at a hearing, and the judge would say, all right, yes, dear worker person, please demonstrate your labor market attachment now. So what that means is, right there, the fourth bullet down, the worker must demonstrate a timely, a diligent, and a persistent work search. Those are the criteria. That's coming out of a court decision. So the court might have affirmed it, but those are the criteria the worker has to use to show the worker is looking for employment within restrictions. Now, what that means, my friends, is we know the type of the search you have to do. It has to be timely, it has to be diligent, and it has to be persistent. We just don't know the amount of effort equals timely, diligent, and persistent, because that is not specified. So that will be determined by each individual judge, or when it gets appealed, by each individual panel. So what do you do, workers? Well, here's what you do. There are several routes you can use to demonstrate your labor market attachment. This slide here, we're going to talk about what I'll call the institutions that are available to help you meet this search requirement. You certainly might use New York State Department of Labor reemployment. You can use the DOL services for, planning and training and so forth. Go on ahead. You're just going to have to use them regularly, okay? You can't use them once. You have to use them regularly, and you might find yourself getting a job. You may also use the Department of Labor one-stop career centers. The career centers that people who are unemployed or smart people who are employed but who want something better, they use these career centers. You can search for jobs. You can work with somebody at DOL, at Labor, to match you to jobs and attend seminars and attend orientations and job counseling. You can certainly do that. You can also hire education or training. That means you're a high school grad or you're a college dropout in your past. You want to go back to college? You want to go back to a training program? Just so long as they are accredited. Well, the college has to be accredited. Training program has to be training you for some new employment. But you can do this, and you can use that to try to meet the labor market attachment. Full-time in college is 12 credits. So if you registered for 12 credits, you're now a full-time student. Maybe you can bring that to your hearing. You're going to have an attorney. I know you have an attorney. Talk to your attorney about this. And that could meet the threshold. You can also apply for financial aid. So you might, let's say you got awarded financial aid to go to college now. You don't even have to part with money out of your pocket. Your pockets might be, impinged because you're not working. You can also do vocational rehabilitation. The state government service for that is called Access VR. See, we have that on screen there. It was known as VESID in the old days. Now it's called Access VR. It's run through the state education department. You can certainly use those services. And guess what? We have vocational rehab counselors on staff here at the board. You can talk to them about that process and they'll provide you education. They're very devoted people, I can tell you with authority because I know them, right? They're good people who want to help you. Now, you need to demonstrate this, right? Right. Well, on screen, we're showing you the form that you would use. It's called the C-258. And the formal name of it is Claimant's Record of Job Search Efforts and Contacts. What this means, my friends, is if you want to demonstrate or if you want to restart, you need to file documents that show the judge exactly what you're doing. You need to file documents that show us you are searching, and you need to file them regularly. You also need to informally, but this is an excellent idea, include a resume in these files. All I can tell you is that the board loves to see resumes from people who are searching for employment and demonstrating labor market attachment. Now, there's another way to do this. You can do both. Don't worry about overkill in this situation. You can do both. You could just flat out perform an independent work search. That means you are looking for a job, you're replying to ads, you're sending resumes and letters. You can do that. You might get yourself a job out of this. But you need to tell us you're doing it. So what this means, you can certainly apply for these jobs and capture as a good idea, as a suggestion, the info that we have on screen. Try, what date did you apply for this job? Who did you apply to? How did you do it? What's the name of the job? What's the type of work? What's the position? What was the employer response? You can certainly do this online because it certainly seems like almost everything is pushing you to apply for jobs online in 2025. But you're going to have to capture the reference number of the job and any email confirmations you got. Did you get an interview? Who'd you interview with? When? In other words, capture all the details and record them on that form, the C-258.1. The name of that form is Claimant's Record of Independent Job Search Efforts. So I can't tell you how much of this you should be doing, but I do think that if we remember the old, make looking for a job your full-time job, that's not going to hurt you. Capture your details about what you've done, record them on these forms, and file those forms regularly and often. There's one more tip I'd like to give. Let's say you have an attorney. Work out with your attorney well ahead of time who's going to be submitting these forms, okay? If the attorney, and I'm speaking to the attorney community as well, if you guys want to submit the forms for your clients, fine, but would you please remember to submit them a good 2 weeks ahead of the hearing. You don't want to show up at a hearing and say, I submitted all these forms yesterday, they're not visible yet. You really don't want to be in that boat. So if you're sending them in on paper, send them 2 weeks ahead of time. It's definitely okay to submit them, monthly, weekly, whatever. And if you're submitting them electronically, if you submit them a day or two ahead of time, they should probably be visible. but let's just not take any chances here. Okay, thank you for that. And now Sarah's back with another question.
All right, everyone. Bear with me 1 second here as I launch our poll. This scenario is Willie and LMA. Willie was 100% temporarily disabled per his treating physician. There's just been a hearing where an IME opined Willie is 50% temporarily disabled. A judge has just decided Willie shall receive benefits under a CCP at 75% disability rate. It's another true or false question here. So true or false, can the payer now ask at the same hearing for Willie to demonstrate labor market attachment, LMA? So once again, so true or false, can the payer now ask at the same hearing for Willie to demonstrate labor market attachment? And I can see that we do have a bunch of responses that are coming in already, so keep them coming. Thank you. And Joe, it looks like we are leaning one way rather than the other.
Are we leaning towards true?
Looks like we are leaning towards true, yes.
All right. The answer that we believe is most possible is true. Let's walk through those 3 bullets because this shows you what can and does happen at hearing. The treating physician says 100% disability. That would keep labor market attachment off the table. There was an IME that said 50% temporary disability. So the judge has decided 75% disability and given a CCP. All right. Well, 75% is now temporary partial. The very same hearing, I don't know if I specifically said that earlier, but this is the way it goes. At the very same hearing, the moment the worker went to 75% temp partial, yes, the payer can say, we would like this worker to now show labor market attachment, and the judge can ask the worker to do just that. Medical care. We're now in the next section, medical care and opinions. All right, there are medical treatment guidelines in force that the providers must conform to or follow. There are 16 of them. We have them on our website, and the providers know about them or absolutely should know about them. The providers must also sometimes request prior authorization in onboard in several instances. One instance is if they are prescribing non-formulary medications. Save that idea for a moment. They are also going to have to request prior authorization if they're proposing to do a treatment that varies from the guidelines. Varies, as in variance. They'd be asking for a variance. And then finally, if the treatment or the testing will cost more than $1,000, they're also going to have to ask for authorization. There is this New York State Workers' Compensation drug formulary, and that contains the medicines that are, it contains the medicines and how they should be used and what should be used when and what's on the A list or the B list and what you need to ask for an approval for to prescribe, et cetera, et cetera. And we're showing you a document from and explaining the formulary right now. Okay? So let's now talk about those prior authorization requests, or PARs, as they're known in the game. The first PAR we're going to look at is the PAR for treatment. So that includes a variance because you're varying from the guidelines or more than $1,000. Here's how it goes. The provider submits the PAR The provider submits the part, not the worker, not the attorney, the provider. This process is between provider and insurer. Okay. Level 1, there's going to be someone at the payer who's probably going to be a nurse. You need some medical background to do these. Probably going to be a nurse at the payer, and they're going to review it, and they will say either yes, granted, or no. So granted, go do your treatment, get your services. No, okay. It is automatically escalated to a physician at the payer now for level 2. And I do have to pause here because we've had a couple of questions from the payer community about what credentials the party who does level 2 needs to have. Okay, it's very simple. You need to be a physician. You need to be an MD or a DO, a physician. End of story. There's no argument here, my friends. Okay, thank you for listening. So now let's say the physician approves or grants. Great, get your treatment. Let's say the physician denies. We're going back to the treating provider now because the treating provider will have access to the denials and the reasons stated. So you now, as treating provider, you have a choice. You read the reasons for denial, and if you can understand why they're denying because you didn't submit something or you weren't clear on something or something else that's correctable or changeable, you can simply reapply at level 1 with the new info. Go ahead and reapply, no problem. And you might just get it granted at level 1. However, let's say you firmly disagree. There's something there, they're not reading something right, you don't agree with their interpretation of something. You can ask to have it escalated level 3 to the board's medical director's office. They will make the determination there. If they say granted, you go on ahead and move forward with your treatment. If they deny, the worker's attorney can ask for a hearing, and then they'll put it in front of a law judge. But that's the process for PARs that pertain to treatment, and that includes the $1,000 threshold. Let's now look at the process for prescriptions, because it is the same except for one critical difference. Level 1, okay, the nurse is going to look at it. Granted, dispense. Not, or if it's granted, payers, please tell your pharmacy people to tell the actual pharmacy to dispense. But let's say the nurse denies, and there's a reason given. There's always a reason given. Okay, level 2, the prescriber has to read the denial and has to see why it's being denied, because there's no automatic escalation to level 2 when it's pharmacy. If you disagree with the reason for denial and you think the paperwork clearly specifies why, you're rational, going to have to ask to have it escalated. So let's say you do, and let's say it's granted. Okay, payers, please tell your pharmacy benefit managers to dispense. But let's say it's not. Okay, prescriber, you can escalate the denial to the medical director's office again. Okay, so that part of it is the same. It's just that level 1 to level 2 over here on pharmacy, you need to ask to have it escalated. We thought that was worth pointing out. Now, independent medical exams. I think this might be the only element, aside from who I am, that we reiterate from the Comp 101. Oh, the payment thing, I know I reiterate too. But This is so important and so frequent that it's worth reiterating. Okay, well, let's say the payer wants to do an independent medical exam. That's when the payer is asking the worker to go see a doctor it is paying to give an opinion about some element of the claim or some element of the worker's health. That's an allowed practice, and I've seen the data, and this can happen 4, 6, 8 times on average in the life cycle of a claim. So it does happen with some regularity. Workers, here's what you need to know. Number one, there is no doctor-patient relationship here. That means this person's not treating you, is not going to treat you or make recommendations for treatment. You're not walking out with a prescription, and there's no expectation of privacy here. Anything and everything you say can be reported to the insurance company. Number two, you may bring a witness. Don't let anyone tell you differently. You may bring a witness. You or your witness may record all the events, video and audio. You know that cell phone you can't put out of your hands? You can turn it on and start recording everything. That's allowed. Don't let anyone tell you differently. You don't have to provide prior notice. You don't have to wait for hair and makeup. You're allowed to do it. If anybody tells you no, you need to go to the next to last bullet and write me a complaint. I'll get to that. The reason that you're videotaping is that you're going to get a report. Everyone's getting the same report. So you as the worker and your counsel will assuredly read this report. And then if there's a finding in the report that you don't recognize, you're going to go to the videotape. And maybe you'll see it in there. Let's say you're the worker, you're going to ask your attorney. The attorney knows much more about these things than we lay people do because they deal with this every day, all day. They might recognize where the finding is coming from, but maybe they don't. Maybe nobody recognizes where this finding is coming from. That's now the point where you're going to file a complaint. And you're going to file that complaint about IME conduct with the Advocate for Injured Workers. Ta-da! And so you're going to send it to my office. I will read it. I will triage it. And the probability is almost 1 that I will pass it to the health provider discipline unit. They review these matters and they might inquire with the IME doctor or the IME company. They might have some questions. The point here is that this agency, the Workers' Comp Board, actually grants a license to the companies who perform these IMEs. And we can remove that license or revoke that license. And we have in the past. We can also revoke the ability for an individual doctor to do IMEs. We have, if there's that kind of a problem going on. Also by conduct, let's say you weren't examined in a medical facility. Let's say the facility was not up to professional medical standards in terms of cleanliness or accessibility or anything else. That's the kind of thing you can bring to my attention. If your doctor says you're 100% disabled, and this doctor says you're 0 disabled, that's not conduct. That's a difference of opinion, and you're going to have to litigate that. Finally, you can claim travel reimbursement to and from an IME. You would use Form C-257, same form you use to claim travel reimbursement from your medical care appointments. We're going to change gears now into the peace and love portion of the session. Best practices for payers. We have a question on PARs that came in. In the case of a PAR request, well, why don't you read it so I can catch up?
In the case of a PAR request for psychotherapy, can the request be submitted to a psychologist instead of an MD?
The payer chooses the education of the reviewing provider. That's an interesting question. I know I said level 2 has to be a physician. That's the MD. I don't know if for psych, if they can use a psychologist who would have a terminal degree, a PhD. My understanding right now is no, but I'm willing to be corrected on that. But I guess the most relevant answer, I could have skipped all that other stuff. The most relevant answer is the payer chooses. So we can't tell the payer. The payer is choosing who's going to review your PAR for psychotherapy. All right. The peace and love portion, because I'm saying this to the payer community as collegially as I can, in as friendly a way as I can, but the board has made some announcements over the years, and we're focusing on recent announcements here, okay? And we're asking the payers to please conform to this. The first one, Workers' Comp Law Section 21A. That's known as pay without prejudice. So if you're a payer, you can begin making payments without admitting liability for a claim under Section 21A. So we're talking about the indemnity here. It's just that there are some rules here. Number one, we're showing you the announcement that was made on September 12, 2023. If Joe knows the date of the announcement, then there you go, at 11:01 a.m. I'll incorporate that next. Point is, if I know the date of the announcement, it's pretty important. If you're going to pay under 21A, your payment amount must be consistent with the medical reports in the file. So if there's a medical in there from a treating that says 100% disabled, you have to pay 100% of the true indemnity benefit, not the comp minimum. If there's a medical that says 100%, you can't pay the comp minimum. You have to pay the true benefit at 100% rate. It is incumbent upon the payer to get the wages. So, you want to get ahead of the game and ask for the C-240, go on ahead. It's just that it's very simple for payers to get the true wages. And then you can calculate the true benefit. That's fine, go on ahead. Okay, so that's the first bullet. That's the second bullet where we are reiterating. In the past, before that announcement, the comp minimum was frequently paid. But no, you can't pay the comp minimum. You have to pay true indemnity. Next major topic. This one, I'm about to save you a lot of work and a lot of expense to my friends in the payer community. The board has announced 7 reasons that should not be used on a C-8.1B. Let's show that announcement, shall we? Okay, this announcement was made on January 6th, 2025. So we're coming up on 4 months that this has been out there, but we have made these announcements before, my friends. So please, you see in the middle, it says payers are not to file C-8.1B based on any of the following reasons. So don't combine 2 of the prohibited reasons. No, you can't do that. The 8.1B is the objection to a doctor's or a provider's medical bill. Okay, you can certainly object to it. But you see that first reason? Please, if the doctor bills the regular rate and you pay the fee schedule, just pay the fee schedule and go on with your day. Nobody's expecting more. You don't need to file an 8.1B saying, hey, they billed a lot of money and we paid the fee schedule. That's okay. No one's expecting you to pay more than the fee schedule. So you don't have to file this. Do you know how many of these 8.1Bs we get here in this agency annually that contain these 7 reasons that we don't ever need to see? So what I'm saying is, would you please take a good long look at this announcement and adopt this announcement into your daily work, please, and save yourself all the work and expense of submitting these unnecessary dispute forms, and then save us here at the board the unnecessary labor and expense that we get from having to go through these. The only thing you're going to do is reduce what we call the friction costs of the system. Okay, here's another one that should be an automatic. The rule is actually deposition fees are due 10 days after the depo's filed. So please do not wait for a hearing and a judge to ask you to pay the depo fee, because you're supposed to pay it within 10 days of filing. That was also in an announcement recently. You don't want to get on the wrong side of this because you don't know who might ask for a penalty and what might happen. Just follow the law, please. Within 10 days of the depo filed, release the money to the provider. You know how much to pay based on the degree of the file, the doctor or the provider. You know what I'm trying to say. Also, let's say we're having some hearings and the judge has asked for a summary of payments. Let's please get that filed before the next hearing, and let's also remember the same dates and timeframes I was mentioning with labor market attachment filings. If you're going to file it on paper, I don't even know if you can, but if you are, get it in 2 weeks ahead of time. If you're going to file it electronically, don't wait until the afternoon before, because you're just submitting a historical summary. You know, maybe submit it a little earlier than that. Thank you for that one. Next, and I only have 2 more, okay? This is the last slide on this. Medical only claims. All right, med onlys are not being routinely indexed. However, if they become lost time claims, they are going to be indexed. So please be aware of this, because lost time is one of the criteria for indexing. So if your med only turns into lost time, and it certainly can happen, well, payers, please update your filings and make your decisions on liability and payments if you haven't done them already. Just be aware, we're now looking to you to do that, okay? Your indexing clock is going to start. Finally, a little background. These topics and more are summarized in efficiency enhancement issue number 4, okay? Everything that these items here that I'm mentioning on this slide, they're coming from efficiency enhancement number 4. That's a long way of saying, if you're not signed up to receive these efficiency enhancements, sign up, because we're making really important announcements in those efficiency enhancements. Thank you. All right, I think we're coming into the home stretch here, Sarah.
Mhm.
We're now going to do appeals and settlements, and then we're going to wrap up and take questions. We will be taking questions, so if you have some, go on ahead and start typing them. Okay, let's now go over the appeal process. There is a process, and we're going to cover it right now. Let's say a judge makes a decision and one of the two parties wants to appeal it. That is possible. Here's how that works. The decision would have to be appealed within 30 days of the filing date. That's going to be in the lower right-hand corner of the decision itself. It's on the piece of paper. Okay. So if you're a worker and you have an attorney, your attorney's handling this. If you're a payer, your attorney's handling this. It comes in, and then the other side gets 30 days to rebut it. Okay, your answer is called a rebuttal. Once that happens, it now goes to the Administrative Review Division, and 3 members of the Workers' Comp Board will join together into a panel, and they'll make a decision. Remember, the Workers' Comp Board is 13 different people headed by the chair of the Workers' Comp Board, and they handle these appeals. Okay. They're going to make a decision. The payer does not have to pay anything while the matter is under appeal. That is a feature of the workers' comp system. They don't have to take any special action, and that's just how it is. But after this decision is made, then the money has to be released if that was the decision. But if not, it can be appealed again. So this is where the path diverges. It can be appealed to the full board, all 13. If those 3 panel members who did the first level all agreed, well, the full board is going to have to use its discretion to take the matter up. That would be called a discretionary appeal. However, if it was a 2-to-1 decision, then that is a mandatory appeal, and the full board's going to get it, and they'll make a decision. However, the benefits, if they were called for payment at the first level, they now have to get paid. Okay, I said that the path diverged because either party, if it wished, it could have skipped the full board unless it was mandatory, and it could have gone directly to the New York State Supreme Court Appellate Division, 3rd Department. That's the portion of State Supreme Court that decides comp, benefit, claim type questions. And I think they also might decide, no, they might not. Okay, they're deciding the benefit type questions there at the 3rd Department. The reason why people tend to go first to the full board and then the appellate division is that we're free. We don't have any charges. The appellate division has some form of a fee for its services. Okay, but here's the important thing to know. When you get to the appellate division, you have left the board. We have no more role there to help you or assist you, or no say in what the decision is, etc. Okay, so that is the appeal process. Now let's talk about settlements. Settlement is a term that is used widely in the public, and when it comes to workers' comp, it is used in error. We freely, well, members of the public freely use the term settlement And they seem to be talking about any payment that they might consider of a certain magnitude or size, but it ain't a settlement, folks. A settlement is one and one thing only in this system. It is a Section 32 waiver agreement. We are now showing you the entire web page we have. We actually have a couple web pages on Section 32 waiver agreements. Here's what it is in this system. It is an agreement of permanent impact that closes the medical care or the indemnity or both in exchange for payment today. Let's go down a little further because I want to show everybody the video. Look at, oh yeah, it's up online. There is actually a video that we made. Yeah, let's see what happens. Yeah. Well, the ubiquitous ads play, but once you get past the ad in 30 seconds or 5 seconds, you're going to see the Section 32 waiver agreement video that we made. That's a big 6 minutes and 18 seconds, okay? Roughly. I wrote the script like 15 years ago, so
It's still there.
still there. Okay, but the point is, you should be watching this video because it explains the rules here. It is a permanent closure. You can't come back for more money if you're the worker. Once you get your money, the payer is not going to come and ask probably for the money back either. I've never seen that happen. I don't even know what criteria they would use. Once it's permanent, once it takes effect, that's it. It is entirely optional. The board cannot compel either party to engage in a Section 32. We are also not here at the board part of the negotiations. That's what I want you to know. You're going to strike your agreement, you're going to submit it to the board, and then the board is going to approve it or reject it. If we approve it, great, you're done. 10 days later, it takes effect, the money moves, you're done. If we reject it, we can only reject it for these reasons. If it's legally unsound, okay, that means it's not done correctly. There are rules about how these things get done, about what the agreement says. If it's unsound or if it's unconscionable, it can be rejected by the board on those grounds. But otherwise, if it's not unsound, if it's not unconscionable, and let's say it gets approved, money moves in 10 days, that's it, you've left the system for that category of benefit that you signed for, okay? You can take the indemnity, close the indemnity, and keep the medical open. You can do that. You are probably going to be dealing with an attorney if you're a worker in these situations. The data actually shows that the more serious the claim, the more likely the worker is to have an attorney. So how do you find these attorneys who are going to represent you? Here is how. Number one, the New York State Bar Association. They will refer you to some names who represent injured workers. There's the phone number, there's when they're open, there's the web page where you can go to request a referral. There's also the Injured Workers Bar Association. This is a collective, a group of the attorneys who tend to represent injured workers. They made a group, and so there's their phone number and their web page, and you can visit them or call them. They'll give you names as well. There is also a group of people, I think there are about 90 of them in New York, who are licensed representatives. These are people who are not attorneys, but they took a very rigorous exam. I've seen the exam, I'm not fooling. They passed a very rigorous exam, and the Workers' Comp Board gave them a license to represent people. If you come to our website and you search for licensed claimants representatives, you can find the list. Finally, let's say you have a medical only claim. You have no lost time, no indemnity, you've never had indemnity, and you're not in a position where you're going to be getting indemnity. You can visit the Bar Association at nysba.org and put workers' compensation in the search there, and they will give you a list of injured workers attorneys who are willing to represent you pro bono for free in this matter of benefit access, probably, because there's no money moving in a medical only, so there's nothing for the attorneys to get a fee out of, but you go this route and the Bar Association will hook you up with some pro bono counsel. The Injured Workers Toolkit. Here you go. Here's the last item, and then we'll do questions. So get ready with your questions, my friends. We have an Injured Workers Toolkit on our website that contains so many resources. It's not funny. We consolidated and gave you links to so many resources for injured workers right here on this one page. If you're an injured worker and you have a claim, or you're going to file a claim, or you're wondering, should you file a claim? Come and look at the Injured Workers Toolkit. We have so much here to help you. I'm kind of proud of that one. Here is our agency's social media presence. You can see 1, 2, 3, 4, 5. We have 5 of them, and then we also have at the bottom, if you want to get notifications from the board about your favorite topic, you can. You don't have to select everything. You can just pick what you're interested in. The 4th one down, I always call out the YouTube page because we have hundreds upon hundreds, literally hundreds of training videos out there, including videos of these sessions, don't we?
Yes.
Okay. So why don't we leave this up while we move into questions, Sarah?
Sure thing. I'm just going to put up this here just in case people have their step away from their computer. I don't want them to think we're done while we're looking through the chat. And then I will pull back the advocate contact information once we start going through the chat, so you can screenshot that page if you want. So let us take one moment to review the chat. Please go ahead and continue to enter your questions in there, and we will be right back with you. Hi there. I just wanted to respond to a question that we had in the chat regarding, is there a way to access all classes offered? Yes, you can sign up to receive notifications, and in that you'll be able to choose which topics you're interested in. And we do send notices of different webinars or classes that we have available. Also, as Joe had mentioned before, on our YouTube channel, there are recordings of all previous webinars and classes that we've had. So they are available there. But if you go to the bottom of the website, on the main page, there is a upcoming webinars section, and that has a bunch of different tabs that you can see, whether it's CMS 1500, PFL, all sorts of different things that we do cover. But I just wanted to point that out there. And just rolling through the chat here, 1 second. Okay, the first question I have for you here, Joe, is the $170 standard in disability, or can the weekly benefit be less?
Interesting question. The friend of ours is asking about the disability benefit, 170. Okay, the disability benefit is 50% of the wage up to 170. So that's 340. if for some reason you are earning less than 340, which actually you'd have to be part-time for that, I'm pretty sure, then yeah, it could be less. It could be less. I casually put your benefit at 170, and if you were full-time, that would be your benefit because there's no minimum wage in New York State that puts you at less than 340 a week.
Okay. Next question here. What is the difference between or when a doctor files an HP1 versus an HP2?
All right, this was a question that inspired a little research. The HP1 is when the doctor, the provider, is disputing the amount paid. We are not finding an HP2 form. Sarah and I both didn't recognize the HP2, and we did a little research here, and we checked our resources. And no, I'm on the board website right now for the list of forms, and there is no HP2 on the website as a form that we're still using. So, you know what? If you have an HP2, I'm very interested now. So feel free to send an email to that email address and show me what an HP2 is. I'm always willing to learn too. I'm asking you to learn, so I'm willing too. Okay.
All right. Our next question here. If an employee has been paid a workers' comp benefit and then receive the settlement, do they have to pay back what they previously received from the settlement? So I'm sorry, does that make sense to you the way I read that?
Yeah,
okay. Thank you.
I'll reframe it into the worker was going along getting benefits and then struck a settlement, struck a Section 32 waiver agreement. Remember, that's a settlement, okay? And you are now going to conform to the terms of the settlement. So the settlement will say whether anything is being deducted because it was previously paid, or that's the most likely thing. And even that, it would be covered in the settlement, okay? That's it. And don't forget, if you're a worker, you have to agree to the settlement. You have to agree to the Section 32.
Okay. Our next question here is on CCP claims. How does the Workers' Comp Board and the carrier confirm that a claimant is being seen by a doctor at least every 90 days? And if a claimant is not being seen regularly by a doctor and medical is not on file, are there cases where the board will direct a claimant to pay back comp payments?
All right, a few different elements here. And while I can logically make some statements here. Okay, number one, CCP, carrier continue payments. All right. How does the board and the carrier confirm that the claimant is being seen by a doctor at least every 90 days? It's a CCP. So if you're an injured worker, it's very much in your interest to go every 90 days to get that medical. Okay. If you don't, then the board, if you don't, then the payer will ask for a hearing. The payer very probably will get the hearing. You'll have to come in and you're going to stand in front of a judge who's going to look for medicals. And if you don't have 90-day medicals, the judge can stop the payments or reduce. Yeah, that's possible too. All right, so that's number one. Number two, are there cases where the board will direct a claimant to pay back comp payments? It is within the realm of possibility. It is not something that frequently happens, but it is technically possible. Okay, so let's just put it that way. And then, of course, everyone sees what's in the file. By everyone, I mean the payer certainly sees it, and the worker can see it. The worker's attorney is definitely going to see it. So don't forget that one. Yeah, let's do something for her.
In regards, I think someone here was looking to see if we have an office in Brooklyn.
We do.
Okay. And I should know the answer to this, and I don't, Joe, but where can I find the information on the website of where those offices are located? Can they just put it into the search bar, or?
Oh, it's the most direct route on our website is if someone goes to the very bottom, the big teal bar that has all the links in it, there is an about the board, and it's there. We might even have a locations click.
Okay.
So they are there. The one it's in Metro. It's like 9 Metro Metroplex or something.
So the best way to be, I think you could find the address right on our website or Google it, and that way you can definitely go to Brooklyn so you don't have to travel so much.
That is true. And if you do want to come to Brooklyn, you have to make an appointment.
Yes.
Okay, so come to the site like Sarah is asking and make that appointment.
Okay, next question here. What happens if your employer does not have workers' comp or PFL insurance carrier, but takes money out of your paycheck for it?
Read that one again, please, because this is a crime.
What happens if your employer does not have a workers' comp or PFL insurance carrier, but takes money out of your paycheck for it?
That's a crime. That is something that you want to be reporting right now. You want to put down whatever you're doing, and you want to report that to the Office of the Fraud Inspector General. If you want to include the compliance office here at the board, you definitely want to report that right now. That would be a crime. And remember, the circumstances are money is being deducted for PFL insurance, but there is no PFL insurance. And the reason I'm going to break it down for a moment is employers are permitted to deduct the PFL premiums from workers. They are permitted to do that, but it's a very small amount over the course of a year. It's approximately $330 over the course of a year. And there's a formula. Like, that's the maximum. If you make less than $89,000, you're not paying that much. Second, employers are not permitted to deduct the cost of comp insurance. That's a second crime. You can't do that. And if there's no policy, yeah, we need to investigate this, please.
Okay, next question here. For how long do I have to wait to receive the checks in the direct deposit way?
You're probably not going to wait because let's say you're getting ongoing indemnity payments. They're due every 2 weeks. And if you're on direct deposit, it is almost certain that you're going to have your deposits made every 2 weeks and you don't have to leave your home.
Okay, I think this is a follow-up here. When does the doctor file or after a decision is made on the C-8.1B?
All right, let's break it down. When does a doctor file the HP1? Doctor files HP1 if doctor believes the services were underpaid. There are some criteria for how many days after payment that you can file, whether it's 30, 60, 90. I'm sorry, I don't know those off the top of my head, but you get your payment, you believe you're underpaid, go on ahead. HP1. That's what the doctor files. So you don't need to be worrying about the synergy, I don't know, between that and the HP1. Okay, probably going to be for different issues. They're probably for different issues. You think you got underpaid and it was not a decision from an HP1. It was not a decision from 81B, just do your filing.
Okay. Next one here. What happens if a client wants to pull out of an S32 agreement within the 10-day period? Can they pull out of it first? And next question would be, in these cases, how does the compensation change, or does it usually change?
All right. There is a 10-day cooling off period associated with a Section 32 agreement. The worker wants to pull out and decides, no, I don't really want to do this. Okay, make the board aware and we will nullify the agreement. Can they pull out? Yes, of course you can. Okay, I just explained how. Okay, you're all set. In these cases, how does the compensation change? It's going, you had a circumstance of compensation before you signed the Section 32. That circumstance continued during the 10-day period, 10-day cooling off period. So if you pull out of the agreement during that 10-day period, whatever was in place right then continues. Everything just continues as it was. If you now need to come back because you were due some benefit and you were not pursuing the benefit because you were taking the 32, well, the 32 is gone, so now you have to come back and relitigate what you were previously willing to waive in exchange for a 32.
Okay. Next question here. What is the time frame for receiving IME reports? What happens if the report is received by the claimant and the board ultimately untimely is received by the board untimely? Are the
Business days or calendar days.
Yeah, thank you.
Yeah, we had a couple of different ideas there, but they're all related to the time frame of an independent medical exam. So how many days does the payer or the IME company, I should say, have to file that IME? I don't know off the top of my head the number of days, but it's pretty tight. It's pretty tight, and it's well less than 30, and I'm not going to guess at what it is, okay? If we can find it out for you right now, we'll tell you. It's pretty tight though. Okay, and what happened? I do know that everyone has to get it simultaneously. The board, the worker, the insurance payer, and the worker's attorney. Everyone has to get it simultaneously. That's number one. If it's untimely, maybe a penalty is possible. You could ask the judge. Because you're going to be dealing with a judge. So there's no automatic penalty. I know that. But, you can ask the judge about penalties there. And are they business or calendar days? They're probably calendar days. We tend to do things in calendar days, but what you need to know about calendar days, here's a pretty good rule of thumb for you. If a calendar day puts an item due on a day when the board is closed, we are closed on Saturdays, Sundays, and known holidays, then the item is actually due the next day when we're open. Okay, that is in the CPLR somewhere.
Okay.
Sure.
Okay. Are people able to receive any weekly or monthly compensation for being out of work due to a medical condition?
Yes, that is what is known as workers' comp. So you have an injury or an illness that is attributable to your employment. Yes, you could receive compensation for being out of work. If you have a medical condition that is the result of something outside your employment, but you still can't work, you could receive short-term disability benefits. That's the $170 a week.
I wonder. It is unusual that the board says it has not received my OC-400 mailed 11 days ago from Long Island. What is the average length of time from receipt of my OC-400 to date of first hearing? Just entering case where injured claimant has 2 open cases.
Right, I think this is coming in from an attorney, a worker's attorney, someone who's representing injured workers. So hi, thanks for attending. Is it unusual that the board has not received the form that attorneys filed indicating they have an injured worker as a client? It's known as the OC-400. So this person is in Long Island. Is it unusual that it might not be in the file yet after 11 days through the US mail to Binghamton, New York and scanned? It is not unusual. So at this point, I would not recommend panicking because we're going through the US mail and we did have a holiday in there. And so it has to pass from Long Island up to Binghamton, and then it tends to take about 7 days for the scanning process to complete to make it visible in the file. So don't panic yet. Can you file those electronically? If you can, that would be even better. So I think I addressed the average length of time. Yeah. Okay. So you're not at panic point yet. If it's 2 weeks and it's not visible yet, okay, now let's think about resubmission. Let's think about checking the address you used because you wanted to use centralized mailing in Binghamton, and otherwise, you as counsel, if you want to check with my office at that email address to see at the end of the week if your OC-400 is visible, just send us a quick email. You could even say, hi, I was on the educational webinar. We'll check it for you.
Great.
Oh, look, we got thank you.
Instant response. All right, well, that looks like it's all the questions that we have today. Thank you, Joe, and thank you to everyone for joining us today. Just a reminder, you can also sign up to receive workers' compensation news, including information on future webinars, straight to your inbox. To sign up, visit the Workers' Compensation Board website, scroll down to the bottom of the homepage and select Get WCB Notifications. We also distribute information via our social media channels, so please follow the Workers' Compensation Board on Facebook, X, Instagram, and YouTube. We thank you all for joining us and enjoy the rest of your afternoon.